All right. Hello, my name is Daniel Hunt. I'm an attorney in Florida and California. I'm a mediator. I'm an arbitrator. I'm a teacher. If you need an attorney, themiamishark.com. We refer you. Uh, we charge. This video is not legal advice. It just explains certain areas of law. So it's not advice for you about your case. No way could I possibly know anything about your case. All cases, need to be evaluated by an attorney who you have a contract with, perhaps. I'm not your attorney unless you have a contract with me. So don't say I'm your attorney. Um, I do offer paid videos on Kajabi that are much longer, much more in detailed, so you can get a better idea of areas of law. I do employment, breach of contract, business, defamation, whistleblower, discrimination, Family Medical Leave Act, landlord tenant, and many other areas of law. I don't give free legal advice. I never would. I charge. I review contracts, things like that. So what's an element? What are the elements of a contract? This is a breach of contract video. You're going to go get the basics. Offer, acceptance, consideration, statute of frauds. Those are very intricate legal theories that require long explanations. Law students take days of classes on what an offer really is. Is it an offer? Is it a gratuitous promise? Is it enforceable? Can it be responded to? These are things that you'd have to go over with an attorney. Acceptance. The other party has to accept. There's two parties. One makes an offer, the other accepts the offer. Do they have an agreement? Maybe. Consideration. A contract has to be for something. Both sides have to give for a contract to be legal and valid. A gratuitous promise, hey, I'm gonna give you $100. I'll do it next week. That's not a contract. That's not even enforceable. It's just a promise that can be broken. And there's no law that you can sue over if that happens. Now, if it's, I'll give you $100 next week if you wash my car every day for a week, and you say, sure, I'll do it. I'll wash your car every day for a week, and next week you give me $100, then you have a contract. Maybe. There's other things, statute of frauds. If a contract cannot be performed within 1 year and it's guaranteed to take more than a year, it has to be in writing. If it's over property, it has to be in writing. And there's a whole bunch of other rules about different types of contracts, which is why if you think you have a breach of contract case, you have to talk to an attorney. A contract has to be understood by both parties. They have to both understand the exact same thing. That's why it's always great for them to be in writing. And then there are other theories around contract. For example, employment law. An employment situation is a contract. If you agree to come to work every day from 9 a.m. to 5 p.m. and do the following tasks, I agree that I will pay you $12 an hour to do those tasks. And I'll pay you at the end of every week, or I'll pay you at the end of every 2 weeks. And that's a contract if you agree to be my employee. Those are things that I deal with on a regular basis. Now, there's other laws that govern employment law, for example, the Fair Labor Standards Act, the Florida Minimum Wage Act. They may or may not apply to your situation. They usually apply to larger employers that make $500,000 a year, deal in interstate commerce, all very complicated legal theories that you need to talk to an attorney about before you can determine whether or not you have a case. It's always better to have a contract in writing. The writing will govern. The behavior of the parties with respect to the contract, if there's any confusion, will govern. There's something called reasonable reliance if you have a contract. For example, I get people that get into contracts, they pick up and move from one state to another, and when they show up in the new state, the employer says, sorry, we don't want you anymore, but I just spent $10,000 to move here, and I gave up my old job. Well, there may be some damages that are owed to the employee based on that. Remember, we're always dealing with the reasonable person standard. So just because you might interpret something one way, that doesn't mean a reasonable person will interpret it that way. What is a judge going to think? What is a jury going to think when they see the terms and the actions of the people? Were you behaving appropriately? Was your behavior based on the contract and your understanding of the contract something that everybody would understand? That reasonable person, that imaginary reasonable person. All right, that's all. Thank you for watching my video, and you can take a look at the links below.